Hello and welcome to The Hindu. On Wednesday, Home Minister Amit Shah moved three new bills allowing the removal of elected representatives arrested on serious criminal charges and held in custody without bail for more than 30 days. The three bills are the Government of Union Territories Amendment Bill 2025, the Constitution 130th Amendment Bill 2025, and the Jammu Kashmir Reorganization Amendment Bill 2025. The bills propose that any prime minister, chief ministers, union ministers, or ministers of state and union territories who are arrested and detained in custody for 30 consecutive days without obtaining bail on charges of committing an offense punishable with imprisonment for 5 years or more shall be removed from office by the 31st day. So, for example, Prime Minister in this situation can be removed by the President or a Chief Minister by the Governor of the state if they do not resign on their own. Home Minister Amit Shah claimed that this is Narendra Modi government's commitment to restoring moral standards in politics. People of the country, he said, need to decide, is it right for a minister, chief minister, or prime minister to run government from jail? Opposing this narrative, leader of opposition in the Lok Sabha, Rahul Gandhi, said that the bills would take the country back to the medieval times when the king could remove anybody at will. Before we get into this discussion, I just want to present you with a small nugget of information that under the Congress led UPA's 10 years at helm, 72 political leaders had come under CBI scanner, and 43 of them, which is 60%, were from the opposition. And under the BJP led NDA's 8 year, now 10 years in power, this number has increased and is now close to 95%. Today, to discuss this very important bill that has taken the country by a storm, I have with me my colleagues Sandeep Phukan and Vijaita Singh. So, Vijaita, I'll go to you first because this is such a complicated bill and one needs to understand the legal implications of it. What does it mean that can a person who is arrested but not convicted be also removed from office?
Yes, so as far as the bill is concerned, the text of the bill says that you if a minister or even the prime minister, chief minister, minister of even the chief minister of union territory and minister in a union territory, if they have been arrested and say if they are in jail or they are in custody and the period is more than 30 days, then they will have to resign. And if they don't resign on their own, from the 31st day, their resignation will be deemed to be effective and they will no longer occupy the office. So, this is essentially what the bill is about. And another aspect of the bill is that they will have to secure bail within 30 days. And if they don't get bail, then also this condition prevails that they will have to leave office. The criticism against this bill primarily is that it goes against the principles of natural justice, that you have to be proven guilty by the court before being pronounced guilty, and but this bill says the opposite. And it is the reason that is being given by the union home minister is that we have the ministers, the elected representatives, they have to be uh, uh, they have to check all the boxes. They have to rise above all suspicion, and till the time their names are cleared, they cannot be governed. They cannot be in a position of governance. They cannot be governing people. Uh, so these are the aspects of the bill. And but there is another uh, point to this. Three bills were presented. One was to amend the constitution. The second was to amend the Union Territories Act, and the third was the JNK, the Jammu and Kashmir, to amend the JNK Reorganization Act, which was enacted in 2019. So effectively, why this was done, why the three bills were brought, because union territories are governed by the Union Territory Act, and Delhi, Puducherry, and J&K. These are the only three union territories which have an elected assembly. So the Union Territory Act, which is being amended, will practically be functional only for. Applicable only for Puducherry. The Delhi Assembly is being covered by the Constitutional Amendment Act, and the J&K Assembly will be covered by the J&K Reorganization Act. So that is why these three bills. And as the statement of objects and reasons says that they should be above suspicion, the elected representatives, and even the Prime Minister has been brought in this, so that there is no doubt that about the sincerity of the government, maybe that we are serious about corruption, and we view this very seriously.
Thank you, Vijaita. I'll come back to you with more questions. But for now, Sandeep, can you please tell me? I mean, the note at which Vijaita concluded that the government has introduced the clause which that this bill is also applicable on prime minister, but we haven't in the history of independent India seen any prime minister being arrested by central agencies that report to the prime minister's office. I mean, ultimately report to the prime minister's office arresting a sitting prime minister, but we have seen sitting chief ministers arrested, and there are several instances of that. Could you please explain the political implication of this particular legislation?
Sure. So, interesting that you asked about Prime Minister and Chief Minister. Well, I recall Prime Minister Narasimha Rao, late Narasimha Rao, being questioned both in the JMM bribery scandal, as it were called, and then in the Lakhubai Pathak case. There were two instances in which he actually faced the investigating agencies, which were under him, but then they were court directed. The other aspect of, you know, uh, you just mentioned about a sitting chief minister. Don't forget that Mr. Kejriwal actually functioned as chief minister from the jail, from within the jail.
Yeah,
He was arrested and for months together.
5 months in total. 5 months in
Yeah,
total. He came out in
yeah.
September
So,
uh,
so
2020.
let us, if you recall that at that point of time, both the BJP and the Congress had made it very clear that Mr. Kejriwal should step down morally, because he's been, after all, arrested on charges of corruption, and money laundering cases were filed against him by the Enforcement Directorate. At which point, Aam Aadmi Party said there is nothing in the constitution that prevents him from being a chief minister. These are all false and fake and fabricated cases by the ruling party at the center, which is the BJP. And why should we resign? That was the argument made by Aam Aadmi Party and Mr. Kejriwal himself. Why he eventually chose to sort of step down and appoint Miss Atishi, I mean, that's a political call that he would have taken later. But their argument was that they have nothing in the constitution that prevents him from carrying on his duties as the chief minister. In any case, Mr. Kejriwal had the distinction of being one of those rare chief ministers who never had a portfolio to himself. So every other department was given to every other minister. So he could actually, continue to function as chief minister from within jail premises. Having said that, I think
Also,
the
I
question.
think, Sandeep, you should not forget that even Rahul Gandhi faced a disqualification because he was sentenced
In
in
a
a.
defamation case with the highest sentence of 2 years. And as you know, the law as it stands today, that if any lawmaker, elected representative, faces a sentence uh, or convicted and faces a sentence of 2 years and above, then he gets automatically disqualified. So that was the case why Mr. Rahul Gandhi, and of course the membership is automatically restored as well if the conviction is stayed. And in the case of Mr. Rahul Gandhi, that's precisely what happened in his previous term as a Lok Sabha member. That's not applicable to this term, of course. But but the case continues. The case will continue. So, yeah, you are right. I mean, in this case, of course, Rahul Gandhi was never arrested, Shobna. He was only sort of sentenced and the sentence was eventually stayed by a higher court, by the Supreme Court. Had this law been in place when Mr. Kejriwal went to jail, and clearly he stayed for much longer than 30 days. So, as Vijaita explained, if you do not resign by the 31st day on your own, then the law empowers the governor, or the case of Delhi, it would have been the lieutenant governor, to remove him by the 31st day, and he wouldn't have continued as chief minister. But once you are left, once you're released, if you're in jail for 30 or 31 days, and I must also add, it's continuous jail, Shobna, not 30 days of different. Suppose you're there for in jail for 5 days, and then you come out, and then you go back again for 7 days, you come out. So that's not the case. It has to be 30 continuous days. Vijayata can perhaps bring more clarity on this point, but my understanding is that it has to be continuous 30 days of jail. By 31st day, you are no longer, you are basically, you lose your position if this law gets passed. But as you know, this is a constitutional amendment bill. It's not going to be easy to get this
Yeah.
passed. And at this stage, of course, it's been referred to a joint committee of
Right. Yeah, we'll come to that, Sandeep. I'll go back to Vijaita because I want to know the circumstances under which this law was brought. What I mean was, did you have an inkling that such a law was coming?
So there is no clarity on why this legislation was brought all of a sudden. It was not in the agreed list of business. Also among the list of bills that had pre-decided before the session commences, and this was certainly not among the bills. But this the government is known for throwing up surprises, as we have seen in 2019 how they brought the JNK Reorganization Act against the norms of circulating the bills amongst MPs to study at least 48 hours in advance, if I'm not wrong. The bill was presented in the House on August 5, 2019 in Rajya Sabha, then and there, and it was decided the same day. So everybody was expecting some kind of a surprise to that effect. But having said that, this was not in the agreed list of business. And one of the speculation that is being done is that it was brought all of a sudden to maybe to deflect attention from the ongoing controversy around and the protests around the special intensive revision of electoral rolls in Bihar. Several opposition parties have pointed out to anomalies and the arbitrary way that the exercise is being done, because it's kind of they allege that many people are being disenfranchised because of a decision of the election commission officials. Some are not diligent. So that is an ongoing thing, and there is a lot of heat on the government. So this is one speculation that is doing the rounds. Other is that the Home Minister said on the floor of the House yesterday that we want to send the bill to the joint committee of both the houses. So when it was decided that you're going to have more consultation on the bill, then why bring the bill in such a hurry? So it gives credence to the theory that this could be done to deflect attention from the ongoing SIR controversy. And that evening, when there was a buzz that something was going to come up the next day on Tuesday evening, this letter by the Home Minister to the Lok Sabha Secretariat that he's going to present a bill which is going to amend the JNK Reorganization Act 2019, which I explained earlier why it has to be done so. So there was speculation in Kashmir also that they're going to amend the act to grant statehood to Kashmir, to Jammu and Kashmir, and that also led to a lot of interest in the subject. But as the evening passed by, we were told by government sources that the bill is definitely not related to restoration of statehood, but it was still not clear what it is about. So by late night, I think a copy of the bill was circulated among MPs, and by that time it was clear that what this bill is about. This is about, as the government is saying, arresting corruption. They want to send a message that this government is strong on corruption, especially it also leads to very good optics because when the NDA government came in 2014, they came on the plank of anti-corruption, and this suits their agenda to that. Yeah.
Yeah. So it is interesting, and of course, some of the news portals also happen to carry, unfortunately, wrong story about JNK getting statehood, and various other speculations were in the air. But Sandeep, I want to come back to you because I have a confirmation that the NDA allies were not neither consulted nor were they informed about government's decision to bring this bill. And as Vijaita has just recounted, this exercise of we knew around 6 o'clock in the evening that the government is bringing some important bills, and it is only at around 10 o'clock that finally we got the copy of what this bill was about. I mean, it is a improvement from 2019 when the bills were actually circulated on the floor of the house. But the more important question is that these are constitutional amendment bills, and there are certain requirements for a constitutional amendment bill to pass. Does the government have the numbers to do it?
No. No. The simple answer is no. Even if technically, even if you assume that in the 543 Lok Sabha member Lok Sabha, you add all the allies of the NDA, the formal allies, and some of them informal, like YSRCP and Biju Janata Dal doesn't have. I think they don't have any MP in the Lok Sabha. So like all other, TRS, Telangana Rashtra Samini, even if you add those, I mean, essentially parties who have been voting with the government on crucial issues for the past 10, 11 years, even then it will not have enough numbers to pass a constitutional amendment bill. So let me explain for the sake of clarity to our viewers what is the difference between a normal statutory law and a constitutional law. So, every bill that you pass, it gets into the statute book. It's called the statutory law. Now, simply what it means is that on any given day, the number of MPs who are present there, it has to, of course, have a quorum. The government simply needs a simple majority. So, out of 273, 274 is what you need to pass a normal bill. But to amend the constitution, to change the constitution, you need what is called as special majority, 2/3 majority. So for 2/3 majority, you need, obviously out of 543, you will need 362, 362. So to get 362, as I said, even if you add up the numbers, unless one of the constituents of the India bloc or some other political party, who have numbers in bulk, like say DMK, for example, of course, a very prominent member of the India bloc, suppose they take a stand that no, on this issue, we will support the government. In that case, only the government will be able to pass through a constitutional amendment bill. They have several of them in the pipeline, simultaneous elections to Lok Sabha and state assemblies, for example. These are again bills which have been agreed to by the NDA allies, Janata Dal, United, even Telugu Desam Party. But in this particular bill, it is going to be very tricky because, as I think one of the Congress MPs, Mr. K.C. Venugopal, if I recall correctly, yesterday speaking on the floor of the House had mentioned that both Chandrababu Naidu and Nitish Kumar should be worried because
Yes. And Mr. Naidu has several pending cases against him, and in fact, he was in jail before, just before he got a bail just before the other.
So these are legitimate political concerns that if you face, of course, I mean these are again, Vijaita can correct me if I'm wrong, but of course, these are serious criminal offenses that will have to carry a sentence, a punishment of more than 5 years in terms of sentence. So only then, of course, this law will apply. It's not for minor sort of transgressions, but if it's a crime which attracts a penalty of 5 years of imprisonment or more, then most certainly this law will come into place. Now, given the fact that many of these opposition leaders have said that this will actually be misused by those in power, not necessarily BJP. See, the law would be the same. I mean, at the moment, it's because it's the center who is moved.
Who is in power?
Yeah, depending on who is in power, it could be misused, and then it becomes a problem. It becomes a problem even in states. So and they can be used to dislodge state governments. They
Yes.
can or destabilize state government. So to quote Mr. Asaduddin Owaisi, he's one of the most powerful speakers in the Lok Sabha. I mean, though he's just one person MP, Asaduddin Owaisi said that this can be actually used to create a police state.
Yeah,
The Yeah, but the government, on the other hand, Shobna, the government's argument is, as you in your opening remarks made it clear, that when you are a public representative, then a public representative should be above suspicion. So your conduct should be such that there is no question on your public morality,
yeah.
and you are completely above board. So at this point, I mean, even on this point, there was a big spat between Congress and Mr. Venugopal. Then referred to the 2010 arrest of Mr. Amit Shah when he was a minister in the state government, and then
Fact,
Mr.
in Rajya Sabha today, when these bills were introduced by Home Minister Amit Shah, the TMC carried certain posters referring, sort of alluding to Home Minister Amit Shah's jail tenure.
Arrest. Yeah, but then he hit back promptly, immediately. I mean, the only reason why those remarks were not expunged from the records is because the minister was present. The home minister was present in person, and he immediately retorted, saying that, look, the cases against me were false and fabricated, but I resigned before I was arrested, and I did not take up a constitutional post until I was cleared by all courts, uh, which is true. He, in the sense that he never took up. He had party positions, but he wasn't a part of the government until the CBI case was discharged.
And this is a story which is ongoing. There will be many more twists and turns ahead as this bill goes to the joint committee of parliament. We shall see you guys soon. Thank you.